Hello everyone, and welcome to the May 2025 edition of My PIP Monthly. This month's presentation is brought to you by Senior Partner Mark Masters and myself, Executive Partner Caitlin Melroy. Today's topics first include our usual most recent case law update. These cases include a very important published decision in the PIP realm that recently came out from the Court of Appeals, issued on April 11, 2025, called Fremont Insurance Company versus Lighthouse Outpatient Center and Michigan Department of Insurance and Financial Services. The second case law update that will be discussed is on Dia Joseph and Healthcare Imaging Partners et al. Versus National General Insurance Company et al., which is another published decision from the Court of Appeals that was issued on April 29, 2025. Lastly, we will focus our discussion on two trending topics in PIP litigation. First, piggybacking off the recent Fremont versus Lighthouse decision, I will discuss the aftermath by way of a DIFS bulletin that was recently issued, and that is 2025-11-INS. Lastly, I will give you all a quick second update on the case of Auto Owners Insurance Company et al. Versus DIFS that was recently before the Michigan Court of Claims. As previously indicated, the case of Fremont versus Lighthouse is a published decision from the Court of Appeals that is certainly one to note in our field. This case is important because it continues the ongoing issue in litigation regarding the applicability of the fee schedules contained in MCL 500.3157. The subject motor vehicle accident in this case took place on September 26, 2018, involving plaintiff Fremont's insured. In April 2023, the insured received post-accident treatment from defendant Lighthouse Outpatient Center. Fremont paid Lighthouse in accordance with the pre-no-fault reform standard of reasonable and customary per MCL 500.3107 subsection 1A and MCL 500.3157. Lighthouse subsequently filed an auto insurance utilization review provider appeal request with DIFS, arguing underpayment. Lighthouse's position in this case was that it was entitled to be paid consistent with the no-fault reform fee schedules rather than the previous reasonable and customary directive. DIFS issued an order on September 29, 2023, agreeing with Lighthouse's position. DIFS held in relevant part, quote, for dates of service after July 1, 2021, MCL 500.3157 governs the appropriate costs of treatment, unquote. In other words, reimbursement rates were to be calculated under the post-amendment fee schedules. DIFS also noted that the Michigan Supreme Court's opinion in Anderi versus USAA Casualty Insurance Company governs the applicability of MCL 500.3157 subsections 7 and 10 to accidents occurring before June 11, 2019. DIFS found that the Anderi decision has no bearing to the outcome of this appeal because the services at issue in this appeal are reimbursable under MCL 500.3157 subsection 2. Fremont ended up appealing the DIFS decision, filing a petition for judicial review in the Newaygo County Circuit Court on October 18, 2023. Fremont's argument emphasized the DIFS decision to erroneously apply the fee schedules by misinterpreting the Anderi decision. Fremont argued that the clear language in the Anderi decision shows that the amended version of MCL 500.3157, all subsections, does not apply to PIP claims for injuries arising from accidents dated before June 11, 2019. In sum, they argue that the rights of both the insured and insurer were vested at the time of the accident and not at the time of the treatment. In response to Fremont's petition for judicial review, Lighthouse indicated that it relied on DIFS Bulletin 2024-06-INS issued January 17, 2024, which stated, quote, in Anderi, the Michigan Supreme Court expressly limited its holding to MCL 500.3157 subsections 7 and 10. The remainder of the enacted provisions, including the remainder of the fee schedule, are accordingly unaffected by that decision, unquote. In sum, Defendant Lighthouse changed its position regarding what methodology of payment controls here, agreeing with Plaintiff Fremont that its reimbursement rate should be the reasonable and customary standard and not by fee schedule. Now, both the insurer and the provider are in agreement that DIF's interpretation of MCL 500.3157 was contrary to its plain terms, as interpreted by the Anderi Court, and is erroneous. The Circuit Court issued an order on March 25, 2024, reversing the DIF's decision, and it held that while Anderi only concerned MCL 500.3157 subsections 7 and 10, the analysis and conclusions equally apply in this case, and thus the reasonable and customary payments previously issued by Fremont were proper here. DIF's determination was reversed, and the appeal as of right by Defendant Lighthouse followed. The Court of Appeals held that the Circuit Court did not err in concluding that the DIF's interpretation of the Anderi ruling was erroneous. The Anderi Court found that the no-fault reform amendments of MCL 500.3157 subsections 7 and 10 to the insureds in that case would result in a, quote, a retroactive reduction of their vested contractual rights to receive uncapped PIP benefits pursuant to the insurance policies and incorporated statutes that existed when they were injured, unquote. Further, the court found, quote, no clear legislative intent to apply the amendments retroactively to insureds with vested contractual rights to PIP benefits under the pre-amendment no-fault statutes, so those provisions do not apply to any insured who was injured while covered by an auto insurance policy issued before, unquote, June 11th, 2019. To sum it up, the court found that the policies and the statutes in place at the time the insureds were injured in an auto accident control their entitlement to PIP benefits per Anderi. In this particular case, the insured suffered injuries from an accident that was before June 11th, 2019. Thus, Lighthouse was entitled for reimbursement for services it provided, quote, under the pre-amendment, unquote, reasonable and customary payment methodology, and the Circuit Court's decision was affirmed. Interestingly, I wanted to note that there was a concurring opinion issued by Judge Ackerman, which essentially brought to light the fact that Defendant Lighthouse eventually adopted the same position as both the Circuit Court and Plaintiff Fremont regarding the applicability of the reasonable and customary standard. Judge Ackerman found that because Lighthouse was not aggrieved by the Circuit Court ruling in the first place, that the Court of Appeals lacked jurisdiction under MCR 7.203 subsection A to review the aspect of the case as to the question of whether the pre-amendment standard continues to govern reimbursement for certain services rendered after the amendments took place. Overall, Judge Ackerman found that the resolution in this case should have awaited a case in which the question was truly contested. The next case law update I will discuss is the case of Dia Joseph and Healthcare Imaging Partners et al. Versus National General Insurance Company et al., which is a published decision issued by the Court of Appeals on April 29, 2025. The fact pattern of this one is a little tricky, but really highlights the ever-evolving issue of the parked vehicle exception and whether an injury arose from a potential intentional act. In this case, Plaintiff Joseph, a Michigan resident, was employed as a commercial truck driver by defendant Kena Trucking. Progressive insured a Freightliner semi-truck that was operated by Mr. Joseph through his employment. Mr. Joseph further had personal automobile coverage through National General for 2 personal vehicles on the date of loss. While driving the Freightliner from Michigan to Texas in March 2020 while working, Plaintiff Joseph stopped at a truck stop in Illinois. While asleep at the truck stop, his Freightliner was allegedly hit in the front bumper by another semi-truck. While attempting to get out of his Freightliner to investigate, Plaintiff Joseph then fell off the sleeper berth and onto his right side. Plaintiff Joseph began an effort to photograph the semi-truck that he believed hit him, and as he approached it on foot, the semi-truck began moving toward him, and another semi-truck began moving toward him from the opposite direction. Fearing he was going to be hit by the other semi-truck and wanting to prevent the alleged tortfeasor from fleeing the scene, Mr. Joseph stepped onto the alleged tortfeasor semi-truck's running board while it was driving past him, held onto his side mirror, and instructed the driver to stop. The other driver accelerated and braked several times, causing Mr. Joseph to fall to the ground again and sustain injuries. The other driver then fled the scene. So here there are two different accidents that we're looking at technically. One where he was allegedly in his truck when another truck hit his and he fell on his side out of the sleeper berth. And then the other when he is trying to grab onto the alleged tortfeasor truck and stepped onto the running board, and when the other driver accelerated and braked several times, he then fell again. In March 2021, plaintiff Joseph filed suit against Progressive, National General, and the MAIPF, claiming that one or more of the carriers was responsible for paying his PIP claim. He further filed suit against his employer, alleging that it failed to maintain required coverage on the involved freightliner. The claims against the MAIPF and the trucking company were dismissed during litigation. Progressive moved for summary disposition under MCL 500.3106 subsection 1's parked vehicle exception as to when Mr. Joseph fell out of the sleeper berth. With respect to the second accident, when he fell from the alleged tortfeasor semi-truck, Progressive argued that under MCL 500.3114 subsection 3, it owed no duty to pay PIP benefits because Mr. Joseph was not occupying a vehicle owned by the trucking company the carrier insured when the accident occurred. National General also moved for summary disposition. The carrier presented the same parked vehicle exception argument as Progressive for that first accident. As to the second accident, National General argued that plaintiff Joseph caused his own injuries and that the alleged tortfeasor driver used his semi-truck as a weapon rather than a motor vehicle. Mr. Joseph argued in response to both dispositive motions that the parked vehicle exception did not apply for the first accident because it involved a moving vehicle, which triggered MCL 500.3105 subsection 1. He did not address Progressive's argument as to the second accident. He argued that genuine issues of material fact remain as to both his and the alleged tortfeasor driver's intent relating to that second accident. The trial court ultimately granted summary disposition as to both carriers and later dismissed the PIP claims against them. Mr. Joseph eventually appealed. The Court of Appeals ultimately held that Mr. Joseph established a genuine issue of material fact as to his entitlement to PIP benefits in relation to both accidents. As to the first accident, the Court of Appeals concluded, pursuant to the case of Kalin versus Detroit Auto Insurance Exchange, that although the first accident involved a parked vehicle, plaintiff was entitled to benefits under MCL 500.3105 because his injuries arose out of the alleged negligent tortfeasor's operation of a motor vehicle. The court concluded that the trial court should have focused on the alleged tortfeasor semi-truck through the lens of MCL 500.3105 rather than the parked vehicle exception of MCL 500.3106 in plaintiff Joseph's Freightliner. Quote, when a moving vehicle hits a parked vehicle, generally there is no need to engage with the parked vehicle exception, unquote, and, quote, MCL 500.3105 applies, unquote. For the second accident, the court found the present case to be similar to the case of University Rehab Alliance, Inc. versus Farm Bureau General Insurance Company of Michigan because Mr. Joseph's injuries occurred when he fell from a moving vehicle used for transportation purposes. The court found genuine issues of material fact as to who caused this accident and whether there was intent on the part of either party involved. The court noted that even though the alleged tortfeasor accelerated and applied the brakes multiple times while Mr. Joseph stood on the running board, Mr. Joseph opined that the alleged tortfeasor did so to flee the truck stop. Ultimately, the trial court's decision was affirmed in part as to the trial court's decision to grant summary disposition for Progressive in relation to that second accident, reversed in part as to the trial court's decision to grant summary disposition as to the first accident inside the Freightliner, as to both carriers, and as to the second accident in favor of National General, and remanded. There's a lot to that one, really. For our trending topics section, I wanted to first highlight the latest bulletin by DIFS, which is 2025-11-INS, that was put out in response to the Fremont versus Lighthouse decision I just discussed, and is important to review in full. In this updated bulletin, DIFS indicates that because Fremont has precedential effect, see MCR 7.215 subsection C2, no part of the fee schedule in MCL 500.3157 applies to the cost of treatment provided to persons injured in accidents before June 11, 2019. DIFS also quotes the case of Spine Specialists of Michigan PC versus Member Select Insurance Company, which we know came out this year as well, which ruled that the tolling provision in MCL 500.3145 subsection 3, quote, does not apply retroactively to causes of action that begin to accrue before the June 11, 2019 amendment became effective, unquote. A cause of action to recover PIP benefits begins to accrue on the date when the allowable expense is incurred per MCL 500.3110 subsection 4. In this latest bulletin, DIFS also provides guidance for providers who believe they are owed additional reimbursement for claims subject to the Fremont decision, which includes appeals with the department's utilization review unit. DIFS also notes that although the fee schedule provisions in MCL 500.3157 cannot be applied to claims that are subject to the Andary and Fremont decisions, such claims remain subject to the, quote, reasonableness, unquote, standard set forth in the pre-amendment version of MCL 500.3157, which is similar to the present MCL 500.3157 subsection 1. DIFS Bulletin 2021-36-INS from October 5th, 2021 governed billing disputes related to no-fault claims still remains in force in its entirety, and that's noted in the most recent DIFS bulletin. Lastly, if you tuned in last month to our My PIP Monthly, I previously talked about the case of Auto Owners Insurance Company et al. Versus Department of Insurance and Financial Services, or DIFS, which was an action filed by 13 insurance carriers against DIFS on September 20th, 2024 in the Michigan Court of Claims. The plaintiff carriers filed suit for both declaratory and injunctive relief, arguing that the Michigan No-Fault Act's fee schedule statute cannot be applied to individuals injured in an accident prior to the June 11, 2019 reform date. On the other hand, DIFS argued that the fee schedule did apply to accidents before that date. See DIFS Bulletin 2023-21-INS. Well, I wanted to provide you all with the latest update on that case after recently looking at the court docket. Last month, we were awaiting a decision from the Court of Claims regarding plaintiff carrier's motion for entry of declaratory judgment. Rather than the court issuing an opinion, it appears from the docket that the parties recently worked out a stipulation to enter proposed declaratory judgment, which is considered a final order at this point. And it is currently unknown whether DIFS will now appeal that decision. We will certainly continue to monitor this particular case for any further updates to provide. That concludes the May 2025 edition of My PIP Monthly. If you have any questions, comments, and/or concerns, please feel free to reach out to myself, Caitlin Milroy, or Mark Masters directly through the contact info in the corresponding slide. Thank you all so much for tuning in.